Good morning, everyone. I'm Dorian Peters, and I'm the treasurer of the Contra Costa County Bar Association, as well as the liaison to the criminal law section. Thank you for getting up this morning and electing to learn with us. I hope you enjoyed last night's kickoff keynote when several of our Bay Area Law School deans discussed the changes taking place in legal education. The law school alumni reception was a lot of fun, and it was great to catch up with everyone. Today, you will have a full day of great programs to look forward to, including a keynote with Novella Coleman of Bay Area Legal Aid. Our event and program sponsors are an important part of our CCCBA community. They make it possible for us to provide events like this. Please support us by supporting them. If you're having any technical difficulties, please have a look at the FAQ tab where you will find troubleshooting tips. On behalf of the Contra Costa County Bar Association, I would like to welcome you to the 26th Annual MCLE Spectacular and this morning's program. You can't do that. I know my rights, protesting in 2020, presented by the CCBA Criminal Law Section. I've worked as a prosecutor, a defense attorney, as well as a police officer. And one of the things I know is that anytime someone yells, "I know my rights," they almost certainly don't. But by attending this section presented by Beth Mora and our Ashley Bargenquast, you will not be one of those people. So with that, I'm going to turn it over to Ashley.
Thank you so much, Dorian. Good morning, everybody, and welcome to You Can't Do That, I Know My Rights. I'm really looking forward to presenting this to you guys with Beth. So, for anyone who doesn't know me, am Ashley Bargenquast from Tully and Weiss. I work in cannabis compliance and criminal defense, and have now been working with Tully and Weiss for 5 years, and I can't even begin to say how much I've been enjoying it and how lucky I am to do so. Today, I'm also lucky to be presenting this panel with Beth Mora of Mora Employment Law. As many of you know, Beth is a fabulous attorney, and she serves on numerous local and statewide boards with legal communities and regularly publishes and speaks on a wide range of employment law matters. She's going to start our panel today starting with protest law. So take it away, Beth.
Thank you, Ashley. And I have to tell you all, I think Ashley is someone you know in your community, but this is my first real experience working with Ashley. She is fantastic and makes me look like a shrinking violet, which for me is fabulous. And so I adore it. So this isn't new to you. I'm sure you all know, and if you watched any of the news, but 2020 is clearly the year of the protest. It is something that even before COVID, we knew we had a lot of protests in front of us, but even since COVID took on the year, we've had lots of protests. We had anti-lockdown protests. We had Run with Maud protests. We had Black Lives Matter, which really kicked off with the murder of George Floyd in Minneapolis in May of 25th of 2020. We have the Black Trans Lives Matter protests, which really culminated in a massive march in June 14th in Brooklyn. And we've had the Juneteenth protests, and we've had ongoing protests in Portland, Oregon, for many reasons, obviously. But truly, this is the year of the protest. Obviously, one of the big issues of Black Lives Matter, and statistically, it may be the largest protest movement in the history of the United States. And that is truly something to keep in mind. Something that is maybe misunderstood. But in, for example, a small window of time, just from, for example, in May to July, there was 15 million to 26 million people in the United States that participated in marches for Black Lives Matter as to the murder of George Floyd. That's a huge number. And if you look at the statistics of that and compare it to what we think about, for example, of the 2017 women's marches, the turn difference is there was 3 to 5 million women who participated in those marches, which we thought was an amazing, huge turnout, and it was. But if you statistically look at the difference, it was dramatically smaller in comparison. Thank you. So if you look at that, there's also some misunderstandings about Black Lives Matter. A lot of people think that the demonstrations are not peaceful, but that is actually a big misunderstanding. Statistically, There's been over 10,600 demonstrations from May 24th to August 22nd. That's just a small window. That does not even cover September and October. Of those demonstrations, over 95% of them have been peaceful. That means truly, even post-protest, when they wound up and people went home, truly peaceful, without violence or out harmed property. And in those protests, they've been nonviolent demonstrations, nonviolent locations, and so of those people themselves and the locations, there's been no damage. But what's important to keep in mind is of those protests, 42% of people, when surveyed, actually believed the Black Lives Matter protests themselves have been inciting violence and destroying property. So even though 95% of these protests have not been violent, have not been people who've been arrested for violence or destroying property, over 42% of people surveyed actually believe they're there to incite violence and creating violence. So what happens is it creates a big misconception about the process, and it also creates misconception amongst the people who are enforcing the process of protest. And that's important to keep in mind as we move forward about what are your rights. Obviously, the most important is the U.S. Constitution, the First Amendment. I don't want to misread this. And then you've got the California Constitution, the Article 1, and importantly, Section 1 and Section 2. One of the things I loved about Justice Ginsburg is no matter how much she knew the Constitution, she carried a pocket Constitution. Always had it. I have it on my iPhone tagged. I am not cool old school like her, but I do think there's never a time we shouldn't have these important documents at our ready. Sorry. So the right to speak freely, and it's not a never ending. It's something that does have limitations. The right to free speech does not extend to libel and slander, obviously. Doesn't extend to obscenity or threats of speech that incite violence or law breaking. You know, we always remember you couldn't walk into a theater and yell fire. These are, you know, constant understandings. So fear of serious injury cannot alone justify suppression of free speech in assembly. To justify suppression of free speech, there must be reasonable ground of fear and serious evil that will result. And you have to meet these standards, but it's important that you understand there are limitations. Those limitations doesn't mean that all free speech is limited. The right to free speech exists to even speech that we don't like, speech that's unpopular. So after you'll see, for example, like the ACLU stands up for the KKK. That's unpopular speech, but they have the right to free speech. As we'll talk about later, there can be limitations on free speech on private property. And there's also sometimes free speech limitations for government employees versus private employees. So the right to free speech applies to public employees or government employees with some exceptions, but free speech is limited in the private employee workplace, and the employer has the right to some of those limitations. You'll also see limitations in the school or the school place, especially for minors. So free speech is more than a protest. It's more than words. It can be things like music, theater, film, and dance. The Constitution does protect things like symbols and expressions of point of view. Sometimes it's a vigil. It can be clothing or mask. We saw this recently when employees of Whole Foods sued because they weren't allowed to wear Black Lives Matter masks, and they prevailed on that lawsuit. It could be candlelight vigils. However, sometimes this symbolic free speech can also be restricted. For example, you can have a drum circle, that's symbolic free speech, but not if it blocks the freeway on ramp, and you may have a vehicle code violation or a jaywalking violation of some sort, so they may overlap. Now off to Ashley, who will speak very, very eloquently about conduct at a protest.
I will certainly try to. I'm sure that all of you have seen a lot of social media legal advice out there these days about what can and cannot happen at a protest, what's allowed and what's not. So let's clear up just a few misconceptions. It'll be a little bit high level, but we'll go through it. I'm recording, filming the police. Now, this is something that there is a lot of information out there on, and the important thing to know is that in public spaces, it's perfectly legal to film the police. If you're in your vehicle, it's perfectly legal to film the police. If you're on your property, it is perfectly legal to film the police. But you can't obstruct them or get in the way of what those officers are doing. And this can include getting too close, because anytime an officer can say that they were concerned with their safety or the safety of what was going on, it's going to be upheld in court if it's challenged, or it's going to be a legitimate use if they stop you from being right in that space. So what you have to remember is that that filming cannot interfere with what the officers are doing, only record it. It's also important to know that if you're on private property, the owner can prevent it. So like Beth was talking about, free speech can be limited on private property, so can the recording of anybody on private property. And it's very important to note that wherever you on, do not hide that you're filming. Because in California, using a concealed camcorder or recorder, audio recorder, where a person has a reasonable expectation of privacy, is a crime. Now, the code section itself, which is section 647J3, discusses a lot of specifics like putting cameras in changing rooms or bathrooms or anything like that. But it's anywhere that there's a reasonable expectation of privacy, which is a standard that at least some of you will be familiar with. So it's good to know that a law enforcement officer performing their duties in public has no expectation of privacy in that activity. However, if they're, doing something, having a private conversation, checking in on the radio, you have to begin to think about where that privacy interest actually begins to exist. And so being very obvious that you're filming, holding your camera up, even saying that you're filming or I'm recording this is important. California is a dual consent state, meaning that you can't just record a conversation you're having with someone without their permission. And so this applies to the same circumstance of filming an officer. So don't hide that you're doing so if you do choose to film an officer. And we have all seen the power of those civilian videos in the protests that are happening now. Papers, please. California is not a papers, please state. Now, what that means is that it is not illegal for you to refuse to give an officer your identification card or identity. Now, in this slide, I say it's not always illegal for you to refuse, because there are some circumstances where you do have to identify yourself. But that is not just generally true. In California, an officer can't just ask to see your papers. Now, not all officers know this, and there was actually a case that the ACLU took about an officer arresting someone for not showing their identification. Please don't ever resist arrest, even if you believe that it is an incorrect one. The point is that it is unlawful, and afterwards there are ways to address it, which we'll be going over. But resisting an officer is a crime, and so always be very mindful of that. The "you can't do that, I know my rights" is not going to stop you from getting arrested. It will help you later. So as you can see here, I have a quote down at the bottom that talks about how the Fourth Amendment itself cannot require a suspect to answer these questions. And there was a case recently where Nevada's paper please law was upheld, but it did require that there be a state law. Now, there are limitations, as I was saying, to not identifying yourself to officers or providing your identification. The most important being, do not lie. Misidentifying yourself to an officer is a crime. It is Penal Code 148.9, and it carries a misdemeanor moral turpitude conviction that can land you up to 180 days county jail. It is not a casual crime, so all of the jokes that people talk about, like, I'm gonna tell them my name is Bart Simpson, like, no, that's a crime. And at this point, they can now arrest you, which brings me to the second point, because in the following situations, you do have to provide an identification card, such as if you're driving and get pulled over, so you have to provide your license, or if you're arrested or booked. So if you lie about it, they now get to arrest you lawfully for lying about your identity, and you do have to provide your identity and identification. Now, the flip side of the First Amendment that Beth talked about is the Fifth Amendment, so specifically the right to not be a witness against yourself, or the right to remain silent. As a criminal defense attorney, I cannot tell you how important this right is and how many people don't understand how to correctly invoke it. So what does it mean? Now, everybody has the right to remain silent. It is not just for people who have done something wrong. It is not just for people who have been accused of a crime. If you saw something happen, you can tell an officer that you don't want to answer any questions, right? You can then, of course, be subpoenaed if there is a later case and you will have to testify, but you don't have to speak to officers at the scene, right? Everybody can invoke their right. And in fact, you must affirmatively invoke that right in order to be protected by it. It has to be unambiguous. And if you are even a tiny bit ambiguous, if you say, I don't want to answer questions, that's not quite enough, right? It has to be, I will not answer any questions. I'm invoking my right to remain silent. What's even better is if you then say, and I want my attorney, because that gives extra protections. And it's also important to note that your right to remain silent can be invoked in or out of custody. Now, I don't know how many times I've had somebody tell me, and they didn't read me their rights. Like, they didn't read me my rights, right? I didn't hear that you have a right to remain silent. Anything that you say can and will be used against you in the court of law. That means none of it counts, right? Like, no, that's not exactly how it works, right? Miranda is about suppressing statements that are gotten through custodial interrogation. So if you aren't in custody yet, right, even if you're feeling like you can't leave, you technically could leave. Even if you're getting pressure put on you, but you're technically not arrested yet, you're not in custody, then it doesn't matter that they haven't read you your rights. And you have to know that. So it's from the very beginning. And a lot of times I hear people say, like, and I was told, oh, well, if you don't have anything to hide, just talk to us. No, please invoke your rights unambiguously, early, and affirmatively. Because that is the right to remain silent. As I was saying, volunteered statements are not barred. So even if you say, I invoke my right to remain silent, I refuse to answer any more questions, I want my attorney. And they say, okay, you can sit there. And then they proceed with their investigation around you. If you then continue to talk and continue to volunteer information when they're not even talking to you, right? Those statements are admissible, despite the fact that you've invoked your right to remain silent. Now, there are certain behaviors that an officer can enact in that are considered questioning, even if it's not asking you a question directly, but it is a very thin line, so don't chance it. So once you invoke your right to remain silent, practice your right to remain silent. Now that right to remain silent, as I was saying, they have to stop interrogating you, but they're allowed to come back later and ask you questions. But your right to an attorney, that means they can't come back. So please, I am invoking my right to remain silent. I don't want to answer any questions without an attorney, and I would like my attorney now, right? Oh, if you have an attorney, I won't be able to help you. I would like my attorney. And that's it. And then just don't say anything. What's interesting to note is that booking questions can still be asked of you, right? That isn't violating your right to remain silent and not answer questions, because the Supreme Court has recognized that routine booking questions are not a violation of Miranda. But be really mindful about only answering exactly the question that they're asking you, right? Because there are lots of ways to answer those questions, and while you don't have to tell an officer where you were coming from or where you were going, you do have to give those what your identity is, your birth date, if you have a medical condition that they need to be aware of, that kind of thing. But be really mindful about when answering those administrative questions that you are only answering those administrative questions and nothing further. Now, important points for all law enforcement interactions. Stay calm and be polite. What a Freudian slip there. So stay calm and be polite to the police. What you need, staying calm keeps the situation from escalating and preventing a misunderstanding. Important, do not interfere with or obstruct the police in any way, right? This is like the recording. Don't get in the way while you're recording, just do so. Affirmatively assert your rights. Unambiguous assertion means that those rights are on the record and there can't be any confusion. Now, do not lie or give false documents. It's a crime to use false IDs. It's a crime to provide incorrect information on there. Just say you don't want to answer any questions. Don't consent to any searches. If at any point they're asking if they can do something, even if they're saying, you know, we want to search the vehicle. Okay, I don't consent to any searches, right? And they're like, well, we're going to do it anyway. Okay, I don't consent to any searches, right? You're not getting in the way. You don't want them to break anything. Even if you're unlocking a door for them so they don't break it down, make it unambiguous. I am not consenting to a search of this area. I simply don't want you to break the property, right? Do not resist the officers. There are some locations that no longer prosecute just resisting an arrest if there isn't an underlying charge, but there are a lot of places that you can still be charged with just resisting arrest with no other charge attached to it. So do not resist officers. And I'll tell you right now, saying I'm not resisting is not proof that you weren't resisting. And then if you do believe your rights have been violated, recall the details and write them down as soon as you can. Record them so that you have them close in time to when it happened to you. So you're not trying to remember however long later when it's going to be relevant. So I'll pass it back to Beth now on what it is that you might have done wrong.
Not that anyone would do anything wrong on purpose, but this is kind of not necessarily common sense, right? So civil disobedience and potential charges. Civil disobedience is kind of the jam this year, right? We go to protests, we speak up, we use our voice. Civil disobedience is the active refusal to comply with certain laws as a form of protest. Even if the expressive activity is viewed by you or the actor or someone you know as lawful, there is a chance that the police will regard it as otherwise. There are many charges that can be brought. And in California, the statutes can be vast. Here are a few examples. Resisting arrest, disrupting the public, riot or unlawful assembly, failure to disperse, disrupting the peace, trespassing, refusing to obey a police officer who's enforcing the vehicle code, and attempting to free a person who has just been arrested. I will say that's the one I find most interesting, and we see more and more of, and you might see pictures of this in the media, someone who's been arrested or detained by the police and peers and friends go in to grab them away. And that, I don't know why people think that's okay, but that will cause a problem, and that could be a crime. Thank you. So arrested at a protest, what is the offense? And, you know, obviously that could be anything from an infraction, a misdemeanor, or a felony. You know, the infraction is similar to like when you get a ticket, and you could get a ticket at the location itself. You have to show a government ID, you sign a promise to appear, and you'll probably and most likely be released there. I will say this whole ID thing is important to keep in mind. If you're an undocumented person, you really need to do your individual research about appearing at a protest and ID issues. And we're not covering it here, but I do want you, if you're advising someone or have your own individual issues for friends or families, to research that independently. ID is an important separate issue. Misdemeanors, this often results in one also being taken to the station, fingerprinted and photographed. And if with proper ID and signing a promise to appear, is often released as well. But with felonies, this is far more different, far more serious. and the individual may be detained in jail. They may have a bail, and if they're not bailed out in 48 hours, a judge will review the police reports to determine if they show a criminal act, and the individual must be seen in court within 2 business days to be informed if they are being charged with a crime.
Fun fact, the 48 hours is always enforced as 72.
Fun. Okay. So we see this a lot, and if you're arrested at a protest, can it impact your employment? So California Labor Code section 432.7, an employer is not allowed to use a person's arrest pending trial as the sole determining factor in making a negative employment decision against them, because obviously that would go against the presumption of one's innocent until proven guilty. I mean, that makes sense. However, an employee can expect their employer to ask questions about the circumstance, about the arrest and the pending trial to determine whether or not that arrest could have an impact on the employer's business. For example, if the arrest could reasonably have an impact on the employer's business, then the employer may take an action against the employee while that arrest is pending. We see these examples most often, for example, for police officers. We saw it in Charlottesville, North Carolina, where a protester in the alt-right group was fired when he was seen on social media. If the arrest is resolved without conviction, the arrest cannot be used against that employee in the workplace. And if someone's wrongfully terminated, they can sue for actual damages under the Labor Code. So political activity under the law. So we're seeing this happen more and more these days because people are going to protests. At the same time, they are also at home, so they're engaging more and more in social media with their friends. They're friending from work, their coworkers, their managers, their HR, and their customers and vendors. And so then as a result, they're engaging in political activity that's being seen by their friends and coworkers. And so there is some overlap. So when they go to press, maybe if they even get arrested, there may be some things that are seen. So you have to keep in mind that an employer cannot discriminate or retaliate against someone or take an adverse employment action for engaging in political activity. There's several labor codes that protect that, 96, 98.6, excuse me, and then 1101 and 1102 for engaging in political activity. You can't be fired, or going to a political protest. There are some exceptions. But it's important to recognize whether or not the political activity was truly political activity. Someone can engage in political activity, but that political activity cannot cross the line to discrimination. So if someone is saying, I'm engaging in a pro-Trump rally, but then says something happens to be racist, that's not protected activity. So things to keep in mind that are happening right now. When people are going to protests and at the same time sharing pictures on social media, they're sharing their friends with their coworkers and peers, is that you are opening yourself to some privacy issues. You are going to a protest and maybe you don't want to be searched. You have just heard from Ashley this very smart advice, I'm not consenting. You probably are smart enough maybe not to even bring your cell phone, so you won't have your cell phone searched, and maybe even take your face identification or your code off so you can't have someone easily search your phone. But maybe you left your social media up with pictures, and now you've opened yourself to some potential privacy issues, and have waived some of your constitutional protections of privacy. You have to ask yourself, if you had a reasonable expectation in privacy that if information you publicly posted on your social media. So you'll have to ask yourself these questions under the California Constitution and the US Constitution. And then you'll have to ask of whether or not these types of privacy issues were violated. And some really important things that may come up is whether or not you were convicted of a crime or not. There could be the California Labor Code section 432.7, which is ban the box, asking questions about criminal activity. Fair Credit Act and Consumer Reporting Agency issues that might come up. Disabilities and medical information. Sometimes people get hurt. at rallies, or they ask for accommodations and so forth, or they talk about their disabilities, or they go to rallies about disabilities and they post this, or religious beliefs. Sometimes there's rallies about religion and so forth. So when people post this information, they have to remember they're putting that out there, and they may waive their right to privacy, and then it comes up in the workplace.
And Beth brings up a very good point about what you're taking to a protest. I didn't do a whole breakdown of the different ways that an officer is allowed to search you, even without your consent. If you're getting arrested, they're allowed to pat you down, even if there's not an arrest. They're allowed to search you incident to an arrest. Knowing what's in your pockets and not having anything illegal on you is crucial. Also, just make sure that if you did bring a joint, that is a perfectly lawful thing to have, that you make sure that the officer knows that that's in your pocket, because if you end up in the jail and then they find that on you, that's a much more serious crime.
Thank you. Point. This next page is really just to help guide you about other things that we see popping up on social media when people are posting, going to protests that talk about civil rights issues, and then they have the interlay between their coworkers and their managers and protest rights. And often the perfect example is someone posts about a presence at the Black Lives Matter protest, another coworker says something that they find offensive, and then boom, you might have an issue, and it overlaps between a protest right, a free speech right, and a civil justice issue in the workplace, and whether or not it's discrimination. And it's this amazing overlap. It's extremely complex, and it's important to highlight these issues and pay attention to these issues. And they're definitely showing up in multiple different ways right now, because we have multiple different overlaps. We have them with immigration right protests, we have them with disability rights and race and so forth. And people are definitely posting pictures of their protests, and then they're highlighting these issues back in the workplace.
Okay, so what happens if you get a prior? If that's a prior arrest, if that's a prior conviction, what can be done after the fact? Now, I want to do a quick overview for individuals who don't practice criminal law, who've never been involved in the criminal justice system. This is the basic process of arrest through conviction, right? So what happens is you have your initial arrest or law enforcement contact. A report is then created by that officer and possibly reviewed by another officer or supplemented. Sometimes they're sent to filing desks in a certain law enforcement office who review it. And then that report is sent to the district attorney's office for review. The district attorney then reviews that file, that report, and decides whether or not it's worth filing charges. At that point, they choose to either file a misdemeanor complaint or a felony complaint. And they file that with the court, and that's where the case itself actually begins. Then you have the process of the case, which of course can go infinite ways, and I won't go into those right now. And then the resolution of the case, whether that's a plea, whether or not that's a dismissal, whether or not that's an acquittal or a conviction at jury trial. The resolution is when the case is done because the individual either has the conviction or has a not guilty, dismissal, acquittal. So arrest without charges. There are many instances where an arrest occurs but no charges are ever filed. Now this is when an individual says, oh, and the police are charging me. Like, no, the police aren't charging you. The police arrested you. The bail agency gave you what you were arrested on, but it is only the district attorney who actually charges an individual, except for indictments, and that's kind of a special other thing. But generally speaking, it's going to be the district attorney's office. So why is it that someone might be arrested but never charged? It might be that they were arrested for lawful behavior and there was actually no crime. A lot of individuals recently have reported that they were arrested basically to stop the protest, but they weren't actually doing anything, right? It was I'm arresting you on a failure to disperse, but then they're never charged on it. It might be that they were arrested on resisting arrest, but they're in a jurisdiction where that alone won't be charged anymore, right? It could be that the officer was mistaken about whether or not the behavior was lawful, right? But ultimately it is a lawful behavior that there's no crime for. Or if you have 600 arrests on your desk from a mass protest, you're not going to send all 600 to the district attorney's office. You're going to pick the ones that the officers believe are most deserving of prosecution, right? It might be, like I was saying, that no charges are sought. The officer decides in their discretion not to send it over. If they have 600 arrests, they're just going to book a bunch of people, and then like the real troublemakers, their reports get sent over, right? When there's something extra, those reports get sent over to the district attorney's office. The variables that come up in discretion and patterns of discretion exercised is an interesting topic that we're not discussing today, but it's very interesting to look up if anybody is interested in that. And there have been some very cool op-eds recently. There's also, it's possible that there's a legal shortcoming or a justification with the case. This is generally done at the district attorney level, right? It could be that upon closer review or in getting more information, the officer themselves see that they're like, this is a clear self-defense case and they don't even forward it to the DA. But generally speaking, the district attorney is going to make those legal decisions, right? So they'll review the case and maybe an element clearly isn't met, right? Not only is it clearly not shown in the evidence, but the evidence actually explicitly shows the alternative. Or maybe, like I said, an obvious justification like self-defense, right? If it's a fight and the person who was arrested looks in way worse shape than the person who is the alleged victim, or if it just is very clear, maybe a district attorney will choose not to charge that. I find that if there's any chance to find that element, that they usually are charged. So say an element isn't clearly met, that could be charged because further investigation might show it. It's usually in the circumstances where the element is like explicitly refuted, where they're not charged. But again, there's a lot of discretion there. I've had a lot of excellent communication with district attorneys while they're reviewing cases. And when we provide them with additional information that maybe didn't make the police report, they choose not to file just, in an interest of justice. So there are lots of reasons to not have that filed ultimately. There are also some diversion opportunities that are pre-filing diversion that we don't go into here, but that's another reason why you might not have a filed charge. You might get that kind of opportunity to do a pre-filing diversion program. So what if they don't file though? You get arrested, it's embarrassing, you're concerned about future jobs, there's often different, have you ever been arrested questions, and you get really nervous about having to tell someone like, yeah, I was arrested, right? Like, what do you do? Well, you have a couple of remedies under the law for how to get rid of arrest records, right? To get them sealed. The kind of most thorough one, if you would, is a factual finding of innocence. This is like the California form equivalent of RBAD, right? So the 851.8 sub A is that there's nothing filed, and so then a petition is filled out and sent to law enforcement, the law enforcement agency that performed the arrest, and the prosecuting attorney of the jurisdiction where it occurred. And at this point, law enforcement could literally go, yeah, RBAD, no worries, and just like sign it and destroy that record and be like, that was on us, right? But often they don't respond to them, right? They don't recognize the petition, or maybe they're like, look, we're not willing to say that this was our bad, so we go to subdivision B. And so if you don't get anything back within 60 days and the statute of limitations has run, you can file this petition with the court. Now, it's important to know most misdemeanors in California are a 1-year statute of limitations. Most felonies are a 3-year statute of limitations. There are certainly a variety of charges that have different or even no statute of limitations. So like take a look, but with a misdemeanor, it'll generally be that 1 year. So it can be a little tough because you can't do anything with this arrest. And if you are arrested on a felony, you technically have 3 years until that petition can be run. So that's when you want to like really talk to the district attorney that you send that petition to. And often the will not file letters are really hard to get because they want to be able to file on that charge if a subsequent arrest and charge happens. So they're tough to do before that statute is run, and the code section itself requires that statute to be run. But say it has run, and this is an arrest from way back when, and somebody just wants to get it cleared, the petitioner can then petition the superior court that would have had territorial jurisdiction over the matter. This can get complicated when things happen in one place from a different agency, gone to a different location, but territorial jurisdiction, and then that the law enforcement agency and the prosecutor is served 10 days prior to the hearing. This would be the second time that they're served, right? Because they got the petition the first time, didn't answer in 60 days, and then get it again. So then you have a hearing that you can have declarations, affidavits, police reports, anything else material, relevant, and reliable. And so the standard is that there was no reasonable cause to believe the arrestee committed the offense for which the arrest was made. You'll see that's a really high standard, right? No reasonable cause to believe. If the court finds that, the burden shifts and the prosecutor's in charge of showing reasonable cause. And then if that isn't shown and the court agrees, the records are sealed and destroyed. And then after 3 years, the order to seal and destroy those records is sealed and destroyed as well. This is the petition to seal and destroy adult arrest records. You'll see there's only one page up here because the other 2 pages are instructions. But if you look up this code, this form, you can absolutely find all the instructions on how to do this. Okay, so what about other relief available that's maybe a little bit easier than 851.8, right? Because that's a pretty high standard to meet. You have 851.91. Now this can apply to both pre or post filing cases. So it kind of begins to meld in here, right? But if an arrest did not result in a conviction, you can file for 851.91 relief. If the statute of limitations has run and no charges are filed, that's your no filing, right? But if a pleading was filed, you can still file for this kind of relief if no conviction occurred, the charge has been dismissed and cannot be refiled, right? So if it's filed, but ultimately the information showed that it was worth dismissing and it was, you can have no conviction and get the arrest sealed. If the conviction occurred and the arrestee has been acquitted, right? So a not guilty at a jury trial. And then if a conviction occurred, but it was vacated or reversed on appeal, all appellate remedies are exhausted and it cannot be refiled. From here, we look at what we have to do. So basically, a person is not eligible for relief under this section if they could still be charged, if they were charged of murder or another non-statute of limitations offense, unless they were already acquitted or found factually innocent. The petitioner intentionally evaded law enforcement efforts to prosecute the arrest. This takes a certain amount of evidence. I won't go too far into it, but let's just say it does take more than bench warrants and failures to appear. And that, or if an individual is guilty of evasion of prosecution by identity fraud, and then subsequently charged for that identity fraud. So really, don't tell officers that you are a different person or give them a different identification card because you are really opening yourself up and limiting your relief. Now the rest of this code section is it's a very long code section. I believe trying to get it on slides, we had like 4 totally full slides that would make your eyes cross. But there's a bunch of minutia in there about what's required, timelines on service, etc. The long and short is file it in the court that would have had criminal jurisdiction. 15 days before the hearing, make sure the form is provided to the prosecutor and the law enforcement agency. Include all the necessary information on that form. And fun fact, this process is supposed to be posted about at detention facilities, and the form's provided upon request. I have never heard of that happening, but people generally are too nervous about being arrested to be like, hey, can I get my arrest record sealed? Like, they're a little bit more nervous about being charged with something while they're actively in a facility. And so there are 2 ways that these can be granted, either as a matter of right or in the pursuit of justice, in the interest of justice. As a matter of right, individuals can get this 851.91 sealed without a conviction unless there's a pattern of arrests or convictions of specific charges, right? So a pattern means 2 or more convictions, 5 or more arrests of separate offenses occurring on separate occasions within 3 years from at least one of the other convictions or arrests. So like, you really, if you're a repeat offender and you keep dodging filing, they're not going to erase these arrests. This is for domestic violence, child abuse, and elder abuse. If you show a pattern of being arrested or convicted of these things, you can't get it sealed later. If you have an interest of justice argument, though, maybe the hardship to the petitioner caused by the arrest, that's the subject of the petition, should be brought up, declarations of good evidence, declarations regarding the arrest itself, if it really is, you have all of these arrests because of like a really sad circumstance where like you've been caring for an aging relative who has dementia and like they keep calling the police being afraid of this, and so you can give this explanation, or, you know, circumstances like that where there is a legitimate explanation for why you keep getting arrested for elder abuse but don't have any convictions, right? You can still present that to the court. They're still willing to listen. And so then at the hearing, you present declarations, affidavits, police investigation and reports, criminal history, etc., anything material, relevant, and reliable. The petitioner has the first burden, then it shifts if the court agrees. So what if you actually win? What if you get this 851.91 granted, right? Now, it's kind of an interesting back and forth on this because the petitioner is released from all penalties and disabilities resulting from the arrest, except for these. It's that it can still be used in a subsequent prosecution for any other offense, right? And it'll have the same effect if it hasn't been sealed, so it doesn't hurt the district attorney's ability to use it. It does not relieve you of the requirement to disclose your arrest if you are running for public office as a peace officer, for licensure by a state or local agency, or for contracting with the California State Lottery Commission, although you can say to private employers that you were never arrested, because that is something that you got. The sealing of the arrest also doesn't affect your ability to have a firearm, right? Now, there aren't a lot of circumstances in which a simple arrest is going to remove your Second Amendment right, but there are absolutely circumstances where that occurs. So be mindful, make sure you listen to your attorney about whether or not that was imposed on you. And then it doesn't affect whether or not you're allowed to hold public office. There are certain crimes that are considered disqualifiers for running for public office. This is the form. It's the CR 409. There's a whole series of them. It's the petition, it's the response, it's the order, right? But the 409 is where you need to start. Okay, but what if they did file on you, right? Like what if they really decided you're the troublemaker that they forwarded the report to the district attorney's office? So this is relief beyond 851.91. You can still do that factual finding of innocence, right? And this provides for it either the defense attorney files a petition on the prosecuting attorney and then a hearing, like we previously pointed out, occurs. You can do it at the time of dismissal. It's my favorite when you get a good dismissal and you get to say, Your Honor, I would also request that at this time 851.8 sub D relief be granted, right? And that allows for the factual finding of innocence. Mind you, you need the concurrence of the prosecutor, so you can't just slip it in, like you have to get their agreement, right? But it's so satisfying. And then subdivision E allows the trial judge to just grant this relief after trial. If the trial is like, oh man, no, that guy was factually innocent. This isn't like a beyond a reasonable doubt standard. The judge is absolutely convinced. 851.85 is basically that same circumstance, right? If they're acquitted of the charge and the judge presiding at the trial where that acquittal occurs finds them factually innocent, right? So 851.86 is also where a person is convicted of the charge, but it's ultimately set aside based upon a determination that they were factually innocent. So that's a kind of a separate process after conviction. So if you have like an appeal or another way to have it put aside. And then the most common thing to do with a conviction is a 1203.4 expungement or a petition for dismissal. The petition itself, as you'll see in a minute, has a bunch of different code sections on it. The 1203.4 is the most common. It applies to cases where they got probation, they fulfilled the conditions of probation for the entire period or discharged early, they're not serving a sentence, not on probation in another case, and not charged with any offense. It allows them to withdraw their plea and entry. So it's the withdrawal of a plea and entry of a plea of not guilty. So they get to withdraw their prior and put in a not guilty plea. It's important to note that 1203.4 sub A and 1203.4A are two different things. 1203.4A, not sub A, is for if no probation is granted, and the distinction between those two can be very minute and sometimes not caught by everybody. So what does it do? It dismisses the accusations or information. It releases from all penalties and disabilities except for Vehicle Code 13555, which is a revocation or suspension of a license through DMV hearings, a firearm ban, or holding public office. And that's because you still technically have that prior felony conviction, so you don't get those rights put back in place, but it's the expungement that is it kind of shows an extra effort of rehabilitation and is often considered, as you're applying for things. But if you add a 17B, you can get extra relief. And that 17B relief is right on the petition form. And it makes it a misdemeanor for all purposes. Now, not every felony crime is eligible for 17B relief. But if the crime was punished through either Penal Code 1170H or was punished by just a fine or county jail time, you can do this. Important distinction, especially for criminal practitioners. There's a difference between if your state prison sentence was imposed versus executed. Sometimes individuals will have a state prison sentence execution suspended. That's still an imposition of a state prison sentence and you can't get it 17B. But if the imposition of a state prison sentence is suspended, then you can. It does not remove, however, the duty to register as a sex offender. This is the CR 180 petition for dismissal. It's 3 pages long. There's a separate order. Always make sure to have your order submitted with your petition. Judges often don't have them with them, and you want to make it as easy as possible to say yes. So that is kind of a fast and dirty what to do with prior convictions and how to protect yourself at protests.
Thank you for coming, everyone. Let us know if you have any questions. We're excited to talk to you about this. And one little tip I don't think we covered is if you're going to a protest and you have any medications, please bring them in the prescription bottle with your prescription on it. Don't bring it separately in a plastic bag and bring 1 to 3 days with you. That's very important. So
Anything that
yeah, go ahead.
anything that could be considered contraband will be considered contraband. You don't want to prove that it's legal later. You want the proof with you.
Good. Be safe.
All right, Beth and Ashley, thank you so much for this program. Very thought-provoking, and I definitely learned a lot. And as the parent of 3 20-somethings, one of whom likes to protest, this is really good information to have. So thank you. Hello, everybody. My name is Teresa Hurley. I'm the Executive Director of the Contra Costa County Bar Association. Oh, and I would also like to thank the Criminal Law Section for helping us put this program on. So everyone here is now invited to a live Q&A that we will be doing immediately after these announcements. Just underneath your screen, you will see a link that will take you to this live Q&A. But just real quick to let you know, the materials and evaluation forms for this program can be downloaded. There's a Files Materials tab that is just above the chat. Any completed evaluation forms can go to Ann Wolf. Attendance certificates will be available soon. If you are a CCCBA member, they will be on our website under your member profile. If you are a non-member or would like more information about obtaining an attendance certificate, just check out the FAQ tab on the main page. Coming up after the break at 10:30, you can either learn how to calm your brain and regain your focus, or you can get tips on how to avoid coronavirus discrimination at work. Those concurrent sessions will be followed by the keynote at 12:30, and that will be Novella Coleman with Bay Area Legal Aid. She will be examining racial bias at the intersection of housing and policing. So something that I think anybody who attended this session would probably be very interested in. Later this afternoon at 2:30, join us for our live Law Firm Marketing Forum program. And a reminder that our sponsor meeting rooms and the section networking rooms are going to be open from 1:30 to 3:30. Finally, if you're having any technical difficulties, please head to the FAQ tab on the main screen. So now, please click the link below to join the live Q&A session with Beth and Ashley. I'll see you there.
Thank you.